They told me to beat it hard. Good afternoon. Welcome to the Procurement-Open government meeting. We have several bills to be heard, and we're going to start now. Our first bill to be heard is SB 36 by Senator Locke, and this is very close to a bill that we had in the House, sponsored by Delegate Cherry, which has to do about definition of meeting and public business. And I think the meeting was, the issue of public business was taken out of the bill in the House, HB 818, and so we want to conform SB 36.
Madam, second.
All right, let's move.
You have to adopt.
All right, let's adopt the substitute.
Move to adopt the substitute.
Second.
And then is there a motion?
You need to vote on the substitute. Favor.
Oh, I thought, all right, everybody vote on the substitute?
Aye.
Move to report a substitute.
Second.
We can go to the board, please. SB 36 is reported out with the substitute, 6-0. I think we'll wait and see if we don't have Senator Diggs here, do we? All right. Yes. Looks like you're up, Senator Rome. 324. Tell us about this bill while
All
we read
right.
it.
Thank you, Madam Chair, members of the subcommittee. Madam Chair and members of the subcommittee, I'm sure all of you remember where you were the first time your bill got surveilled. It took 7 years for mine, but it finally happened. So, Madam Chair, SB 324, it went into Senate General Laws, and we had a very robust debate with it and everything. I made a lot of compromises and went over to Senate Finance, and that's where our esteemed majority leader decided to slap a reenactment clause on it. And nothing makes you love your work more than knowing that you got to come back and do it again. Now, there is one thing that is important with this, why the bill is still worthy of living. So what the reenactment clause of this bill now does is it basically sends it back to the FOIA Advisory Council to, for further study and for recommendation. So they come back and they have recommendations for number of free hours that you could have for a FOIA request, the cap that you could put, or that localities would put on the amount of money that they can actually charge for a FOIA request, or rather what the cap that we would put onto that, and anything else that regards different exceptions or whatever regarding FOIA fees. What has struck this in the first place, reason I've carried this year after year after year, including when I was a member of this body, is, I had a constituent, Stephanie Miner, and she was charged $8,800 to watch a 90-second video of her autistic daughter being dragged off of a bus. That had to be talked down to $2,500, which was still just absolutely absurd. And it just highlights, this is one episode of many, many, many times where it highlighted how FOIA fees are used as a deterrent to the public actually having access. So what we will do here with the version in front of you is, number one, we will have the FOIA Advisory Council give this another look. Number two, the bill that's in front of you is basically going to be the outline from which the FOIA Advisory Council does its work. And so that means they're going to start from the position of looking at 1 free hour for 1 request in 1 calendar year that someone can make. Number two, a $40 an hour cap from that. And then number 3 is a larger question about whether to charge and when to charge for attorney's fees, which would obviously exceed the $40 an hour otherwise. So with that, Madam Chair, I'm happy to take any questions.
Thank you. And so this is that what this bill before us now is, and the
Yes.
reenactment?
Yes. Madam Chair.
Questions, comments from our members?
Madam
Delegate
Chair,
Bloxham.
I guess my question is, are we assuming what the answer is going to be by you sending this bill to them?
So, Madam Chair, I would tell the delegate the answer is no. Basically what we're doing is we are giving them the guidelines that we gave them the same way in 2020 when we had done something similar with this. It was the will of the committee in this case to send it back for more or less another look. This is just the guiding document. What ends up happening in the FOIA Advisory Council, Madam Chair, and to Delegate Bloxham here, is that you've got a lot of members from the public and a handful of legislators, and they will take a lot of public comment, they'll debate among themselves, and then they're going to basically look at a lot of data, a lot of whatever else, and they're going to, if they like this, and they'll ask me, hey, how did we get to these numbers compared to what I had introduced before, which was $33 an hour cap. I'll be able to refer and say, hey, I was copying the policy that they do in Colorado, for example. The 1 hour, here's where we got to that, blah, blah. And so they'll have a very long dialogue and back and forth until they settle on something that the advisory council can vote on and then make a recommendation thereof.
Follow up? Anyone else? All right. Anyone to speak in favor of this bill?
Thank you, Madam Chair. Megan Ryan with the Coalition for Open Government. Wanted to thank the senator for sticking with it for all this time because it has been a long slog. And I think that she's right that, when we get to the FOIA Council, there's going to be a whole bunch of options on the table. We can start from this position so we can actually work this out with stakeholders. So we support the bill.
Thank you.
Thank you, Madam Chair. Catherine Ford with the Virginia Press Association. I would associate my comments with Megan Ryan's. We thank the senator for bringing this forward and look forward to working on it in the interim. Thank you.
All right, thank you. Any comments in opposition to this bill? All right. All right, committee moves by motion.
Move to report. Second.
Let's have a vote on the board. Senator Rome, your bill report 6-0.
Thank you, Madam Chair, and thank you so much to my former colleagues, plus a newbie.
Oh, yeah, Alex Stewart is here.
Diggs is here.
Senator Diggs. Yeah. Senator Diggs, let's hear from you. And you have SB 204, I believe, and tell us about your bill and why we need it.
Thank you, Madam Chair. This is a pretty simple bill. Let me just lay out a scenario. You're a victim of a crime, your car is stolen, and you report it to your insurance company. Your insurance company quickly wants a report, or you get your attorney involved because maybe it's a civil matter. They quickly want a report from a law enforcement agency. However, the law enforcement agency, under current law, is required to send the victim a letter saying that they have 14 days to object to releasing this information to the requesting party. The purpose of that is to protect the identity and the details of the crime from other uninterested third parties. Though what this bill simply does is says that if a victim's insurance company or their attorney makes the request, then the 14 days is waived and there's no need for law enforcement to send a letter or for the 14 days to start ticking and delay that process, because law enforcement agencies want to get out this information as quickly as they can to help resolve the situation, whether it be with an insurance company or an attorney.
Thank you. Any questions, comments from our members? Anyone to speak in favor of this bill? Anyone to speak in opposition? Committee moves by motion.
Madam Chair, move to report.
Second.
Motion has been made and duly seconded. Let's go to the board. Senator Diggs, your bill reports 6-0.
Thank you, Madam Chair.
Senator Perry.
Good afternoon, Madam Chairman, members of the committee. I'm here on Senate Bill 215. This bill is a small amendment to 2.2, 3706.1. The bill permits, currently the way the law is that you can request various files if you are a citizen of the Commonwealth. As a former prosecutor, I would occasionally have cases where someone, particularly victims of domestic violence, victims of stalking, would move out of the state as a way to try to escape their abuser. And as part of that, that would then preclude them from being able to request their non-ongoing criminal files anymore. And that became relevant in a couple of different situations, but this bill just seeks to correct this. I have worked with the Virginia Sheriff's Association. We don't think it will be that many files, so that will be impacted, but certainly the people that it will impact, it's meaningful to them. When I spoke with them, they said typically the way that victims of crime are now required to do it is to go contact their, like a local TV affiliate and get them to then request the files. And I'm not quite certain that that's what we need victims of crime to have to jump through that hoop just to get access to what is, report about what happened to them. I'm happy to answer any questions, though.
Thank you. Any comments, questions from our members on the committee? All right, anybody in the audience to speak in favor of SB 215? Anyone in opposition?
Move to report.
Second.
Motion has been made to report and duly second. Let's go to the board. Senator Perry, your bill reports 6-0.
Thank you.
Salim is here.
Yes, Delegate Salim.
Thank you, Madam Chair. I have Senate Bill 340, which clarifies that the name of public employees, officer, or official as it appears on the purchase card, statement, or other payment record, and the description of individual purchases are not exempt from disclosure by the state comptroller. Currently, there is no specific guidelines on whether the names could be redacted or not. However, the state took a position based on Bank of America's conversations with them. And in 2020, the state comptroller took the position that when a FOIA request for purchase cards credit card statement is made, the account number and the employee's name on the purchase card should be redacted. The few bad actors, government employees who may engage in inappropriate behavior, should not be able to hide behind redacted documents, while the vast majority of the honest and proper government employees have their name tarnished by the redaction. And of course, when it comes to PCI Security Standard, Council defines credit card data as full account number, which is already exempt under the Virginia FOIA regulations. So, in addition, clarifies that certain specific details, such as names of public employee, should not be redacted without further guidance. And that's what this is asking, is when a FOIA request comes through, if a credit card, the first 12 digits are redacted, there's no reason for the name to be redacted either.
Thank you. Questions, comments from our committee members? Is there anyone in the audience who'd like to speak in favor of this bill?
Thank you, Madam Chair. Megan Ryan with the Coalition for Open Government. We support this bill. We thank Senator Salim for bringing it at our suggestion. And you were very well familiar with this issue as they approached you in 2020 to ask you to carry a bill allowing them to redact the name. And you wisely said, no, I'm not going to carry that legislation. And so we think that we should go back to making it very clear that the name stays on the purchase card so that we know if the purchases were authorized. Thank you.
Thank you. Any other comments in favor of this piece of legislation? Anyone in opposition? Committee moves by motion.
Second.
All right, motion's been made, properly second. Let's go to the board. Senator Salim, your bill passes 6-0.
Thank you, Madam Chair.
Senator Stewart, good to see you.
Good afternoon, Madam Chair. Madam Chair, members of the committee, I've got Senate Bill 415, and it amends the definition of a meeting under the Freedom of Information Act. And just a bit of background, there was a case a couple years ago in Prince William, a few years ago in Prince William, which sort of flipped everything on its head, as we understand FOIA. Now, Megan will disagree with me. If she's still here, she'll disagree with me, but she's the only one that disagrees. So what happened was, after George Floyd's death, there was and excuse me, I'm sick and I'm trying to get through this. There was an NAACP meeting in Prince William County, and it was a big deal because there were riots in the streets and there were other things going on. Ultimately, all those supervisors in that county attended that NAACP meeting, and it was an open meeting. It was open to the public. Everybody in the world was there talking about what had happened and what we needed to do and all that sort of thing. But somebody sued them, and I don't know who the plaintiff was, and the Supreme Court, it was the only time I've ever seen a Supreme Court opinion where the majority was correct and the minority was correct in the opinion. The majority was correct in interpreting the language that we have under that act to say you can't do that. The minority was correct when it said when you interpret the language literally, you come up with absurd results. And in this case, we came up with absurd results simply because they hadn't posted that on a website that they were going to be at that NAACP meeting. So now we're not sure where we need to be when it comes to these supervisors going to meetings. You all will see a number of bills that we vetted very thoroughly in the FOIA Council this summer, and this is one of them that's a recommendation of the FOIA Council, and it allows our local members of political parties to go to their political party meetings as long as the purpose of that meeting is not to go to transact county business. And you all know as well as I do, there's certain parts of the states where all the supervisors are in the Democratic committee, and there's certain parts of the state where all Republicans are in the committee. So what you find yourself doing is you'll have two members go into a political meeting, and two of them have to stand outside somewhere else, and one of them has to stand over there, and they can't. It's ridiculous. It really is absurd. I drafted this, in all honesty, you see the way this bill reads, and I hope the Supreme Court is listening, and I said the same thing on the Senate side, as long as the purpose of the meeting is not to transact public business. But surely if you're in that meeting and a constituent asks you a question, you should be able to answer that question without fear of running afoul of the law. And so that's what the bill does. We, meaning the FOIA Council, believes this is necessary to provide them the opportunity to go to their local committee meetings. You know, we enjoy an exemption that others don't, but certainly our supervisors need to go to their county meetings just like we need to go from time to time. I'm happy to answer any questions.
Thank you. Committee questions from committee members? Concerns? Anyone in the audience to want to voice support of this measure? Anyone? Oh, here we go.
No, only Megan.
You set me up. I couldn't not. Megan Ryan, Coalition for Open Government. On the one hand, I feel like this is already covered in lines 32 and 33, where it does allow, a meeting, two or more people from a public body to be in a meeting, whether that meeting is the PTA meeting or whether that meeting is of the political party. On the other hand, I don't know that we do want to, make sure that they can be there answering questions from constituents, because that has turned into them being just present and then them transacting public business. The senator mentions it being the absurd result of someone having to step outside, and I don't see that as being so particularly absurd. It happened on my own board of directors when I had 3 members of the FOIA Council on my board at one time. And when we talked about my business, we stayed in there. When we talked about FOIA Council business, one of them got up and walked out. Now, I know that is very awkward, and it's probably not what people want to do, but if we're going to protect the public's right to see the discussion and transaction of public business, then we should keep this as narrow as possible.
Thank you. Any other questions?
And Madam Chair, if I might just respond to that, because Megan and I agree most of the time. The issue here is this. These were open meetings. The meeting at the NAACP in Prince William County was an open meeting. Everybody in the world was welcome to come because they were trying to solve a problem. But yet the Supreme Court of Virginia said they had violated the law. To me, is absurd. It's the same thing. These committee meetings are open meetings. The whole point of the Freedom of Information Act is that we don't want people going in the back room, deciding our business, and we not know what's going on. And after that Prince William case, I would have agreed with Megan about that language prior to that Supreme Court ruling. But this is the whole reason that we are now. You're going to see several bills this year that amend language in the Act simply because of that bill. This would be different if we were talking about a closed meeting, but we are talking about open meetings with the public sitting there listening.
Thank you.
Madam Chair, move to report.
Second.
We had one. Do you have a question?
I think the senator answered. Madam Chair, I think my question I was about to ask was just to further sort out whether or not this was in fact already a provision, as was stated when Megan came to the podium. And I guess my concern that I just want to continue to think about is if this is then providing maybe too much the other direction, in terms of would if someone wanted to use this in a negative way, have the opportunity to have cover that we may not actually want them to have. And I think that's sort of the concern I have, just to make sure that, we're staying right in the middle of the lane where we want to be with what you're trying to solve.
And Madam Chair, we drew this very narrowly. If you read the language, it's drawn very, very narrowly. But again, at the end of the day, these are public meetings. And I've been on the FOIA Council since I was elected, and I hear a lot of these bills year after year. And I always keep in my mind that transparency is our goal. And I wouldn't bring this bill if this was about closed meetings. This is about open public meetings. And as long as members of the public are in attendance and listening to what happens, then I think we've accomplished what the Freedom of Information Act was set out to do.
Delegate Coiner.
Madam Chair, I have a question. I guess, I don't know, for council or maybe the patron. So when we're having a meeting, it gets noticed on our government website or somewhere, right? There's notice that the city council is going to have a meeting. So you can also notice and say all members of city council may show up at the NAACP meeting, right? That gives notice. So, or they may not, right? You've given notice. So is what your bill saying is that we're not going to give notice that folks may show up at this NAACP meeting, just the act of having the NAACP meeting being a meeting that's open to the public is now sufficient to be open. Is that confusing, or does that make sense?
Senator.
Madam Chair, no, that is my point, and that was the dissent in the Supreme Court's opinion as well. That was a perfectly open meeting, but nobody put on the website that all the supervisors may end up being at the NAACP meeting. I mean, what's the point? I don't understand the point of that, because then if that's not done, how do they know? If I have a catastrophe in my district and the NAACP calls me and says, Richard, I need you to come to this meeting, I don't know what they're doing with the rest of the supervisors. And I'm going to go respond to my constituents because that's what I was elected to do. I'm not going to stop and call people and say, now, wait a minute, who's going to be there? We need to figure this thing out ahead of time. I'm going to go respond to my constituents and deal with the issue. That's a separate issue. This, because of that ruling where we used to think supervisors could go to a political meeting, now I think clearly they cannot. This bill will allow them to go because in different parts of the state, Northern Virginia, they're all Democrats. Other parts of the state, they're all Republicans. They're probably violating the law, and we don't want them to violate the law.
Delegate Corner.
Madam Chair, I guess speaking of the bill, I guess I view it a little differently. If you're going to your local Republican or Democrat committee meeting, right? You're going because you're a member of that organization versus being invited to attend an open meeting because you're elected. So I just view it a little bit differently. I understand the issue you're trying to fix and address, and I agree with what you're trying to do. I'm just not sure if it doesn't make it broader than what you intended to be, but I'll keep thinking about that.
Madam Chair, this specifically says political party meeting if you read the bill, as long as it's not to transact government business. So it says you can attend it if it's your political party meeting, as long as it's not called to transact public business. All I said was when you're there, you ought to be able to answer constituents' questions. Because if you and I refuse to answer people's questions in a meeting, we get kicked out. So why should we treat the supervisors any differently, is my point.
Madam Chair, I renew my motion to report.
Second.
All right. Motion has been made, duly seconded. Let's go to the board. Senator Stewart, your bill reports 6-0. Hope you feel better.
Thank you, Madam Chair, members of the committee.
All right. Do we have anybody? The staff. Senator, the staff.
Morning, Madam Chair, members of the committee.
260.
Yes, ma'am. Senate Bill 260. So, Madam Chair, members of the committee, Senate Bill 260 is what we call giving preferential treatment to Virginia companies for manufactured goods. And if you look at line 11 through 13, it prioritizes Virginia manufactured goods first and the U.S. second for state procurements. And line 14 through 16 gives Virginia manufactured goods a price matching option. And the bill has been recommended by, and this came out of the Public Body Procurement Work Group report on Virginia Public Procurement Act, which met over the summer. And this puts us in line and similar to our surrounding states, D.C., Maryland, West Virginia, Pennsylvania, Tennessee, Texas, and North Carolina. Madam Chair, what this does is...
Senator DeSteph, do you have a substitute?
I don't know, Madam Chair. Do we have a substitute?
I believe you do.
Okay.
Senator DeSteph, we had I believe, a committee substitute, which reads, Ms. Benz, can you please read the substitute for us?
Thank you, Madam Chairman. The committee has prepared a substitute, which essentially is going to keep subsection A, providing the preference for goods produced in the United States, but is going to remove the language in subsection B that offers that price match option, and remove subsection F. And so essentially what the bill is going to do now is just provide for that secondary preference for goods produced in the United States.
Senator Steph, would you consider this a friendly amendment, a substitute?
Madam Chair, I would. And just to continue through the process, I know it's very early in the process, so I'm sure we can work it out, but I definitely need a chance to review this. Right now, it's fine. I'm happy to accept the substitute and move forward.
Madam Chair, I move the substitute.
All right, all in favor?
Aye.
Let's vote on the substitute then. We knocked it out. You want to continue your discussion, Senator DeSteph?
Madam Chair, I'm happy to answer any questions. I don't have any real issues with the substitute. It makes a couple of, it deletes our paragraph D, and I mean, that's fine with me.
All right, thanks. Anyone to speak in favor of this substitute?
Madam Chairman, members of the committee, Stacey Gordon with the Virginia Manufacturers Association. We've been working with the senator for a few years on this legislation, and I haven't had a chance to look at this substitute. However, just speaking on the bill as intended originally, really the heart of it was the bid matching portion, which we strongly support and continue to support. Allowing, basically saying in the procurement process, is we can make a product in Virginia at a competitive price, then we should give our state taxpayer dollars and reinvest back into the community. We, of course, we do understand there were some concerns raised about the language, but I just want to remind the committee that this did pass unanimously out of the Senate. We look forward to working with the committee and as the bill moves forward in the process, but just to restate that we do support the original language. Thank you.
Thank you. Anyone in opposition to the substitute SB 260? All right. Any more questions, comments from the committee members?
Madam Chair, move to report as amended, substituted.
Okay. All right. There's been a motion made. Duly seconded. Can we go to the board, please?
Madam Chair, members of the committee, thank you very much for your time today.
Thank you, Senator. Is there any other business to come before the committee? We've completed it. All right. Thank you so much. Committee is adjourned.